Welcome to day 49 of the Boat and RV 100 series. I am Joe Downs with Storage Moguls, and today I'm going to walk you through the 8 lease clauses that change when the stored asset has a title, a hull number, and a value that starts at 5 figures. And if you want everything we cover in this series backed by a community of people actually doing it, come find us at storagemoguls.ai because we're a community of real operators sharing what actually happens in the field, not what the textbooks say. Folks, a mogul isn't just someone who holds a deed. The definition is of a sophisticated operator of real estate assets. For us, really, it's someone who's mastered the full arc from finding a deal to running one. That's what we teach because that's what we do. We don't just buy storage, we acquire and we optimize it. And there's a difference, and that difference tends to be worth tens of thousands of dollars per deal. We're real people. We're made up of couples, individuals, partnerships, people just like you and me, though. Just because I'm on video and, I've acquired 20 facilities doesn't mean I wasn't just like you before I even knew what storage was. And that wasn't that long ago. Nobody here is selling you a dream from a stage they stepped off years ago. We're actively evaluating real deals. The sweet spot, 400,000 to 2 million. People ask why that range. Well, that's where the deals are. And that's the range that's the easiest to buy and to finance. And that's the range where the big institutional players, they can't play in that range or that pond, we call it. And guess what? Storage Moguls, we'll show you how. You can start for free, advance at your own pace. And so, all right, let's get back to today's episode because if you're using a standard self-storage lease template for your boat and RV facility, you're going to have gaps. And in this vertical, those gaps tend to show up at the worst possible moments. So here's why that lease matters more in boat and RV than in self-storage. In self-storage, a tenant stores personal property. If something goes wrong, a lien process, a damage dispute, an abandonment, the legal framework is relatively standardized and pretty well understood. In boat and RV, a tenant stores a titled vehicle. A boat has a hull identification number. An RV has a VIN. Both have insurance policies. Both have documented values. When there's a dispute about damage, about an abandoned vehicle, about a tenant who stopped paying but left a $120,000 boat at your facility, the specific language in your lease determines how that situation gets resolved. Self-storage lease doesn't address the vehicle identification, moving condition documentation, the abandonment process for titled vehicles, or indemnification for damage during access. The attorney who drafted your self-storage lease may not know what they don't know about boat and RV leases and managing a facility. I highly recommend working with an attorney who's drafted leases specifically for boat and RV storage or marina storage. The 8 clauses we're covering today are the ones that matter most and the ones most commonly missing from adapted self-storage templates. So clause 1, vehicle description. At move-in, your lease should document the specific vehicle being stored, make, model, year, VIN for RVs, hull identification number for boats, length, and the license plate number or registration number. This matters for 2 reasons. First, it establishes exactly what's stored at your facility, which is relevant to insurance claims and damage disputes. And second, it's essential to the abandonment process. If a tenant stops paying you and eventually needs or you need to initiate a lien proceeding on an abandoned vehicle, you need the vehicle identification information to do it correctly under your state's law. Without it, the process becomes significantly more complicated. Clause 2, size presentation. The tenant confirms in writing that their vehicle fits within the assigned space and that they've measured it. This is particularly important for covered or enclosed spaces where the clearance is fixed. If a tenant moves in a vehicle, or if they move in a vehicle that's 2 feet longer than their space, you're going to have a problem. And if the lease includes a size representation, you have a document that establishes the tenant's responsibility for verifying fit. So require a physical measurement at move-in for covered spaces and document it in the lease addendum. Clause 3, condition at move-in documented with photos. Before you accept the vehicle into storage, photograph it. All 4 sides, the roof if accessible, the hull if it's a boat. Document any pre-existing Damage, scratches, dents, oxidation, existing cracks. Sign off on the condition report with the tenant present. This protects you in the most common dispute in a boat and RV storage, which is a tenant who claims their vehicle was damaged while in your facility when the damage was pre-existing or happened somewhere else. Without documentation, you're in a he said, she said situation about a vehicle worth 80 grand with a signed condition report and timestamp photos. You've got a record. Build the photo process into your move-in workflow. It takes 10 minutes and can save you significant grief in the future. Clause 4, no live aboard or habitation clause. This one's straightforward, but frequently missing from adapted templates. Boat and RV storage facilities are not licensed or zoned for residential use. A tenant who begins living in their RV at your facility creates zoning risk, insurance risk, and operational problems that can compound quickly. The lease should explicitly prohibit habitation, define what constitutes habitation, and give you the right to terminate the lease if the clause is violated. Include a provision that allows you to conduct reasonable inspections to verify compliance. Clause 5 is the winterization recommendation. We've covered this in day 46, and the language matters. The lease should include a winterization advisory that recommends tenants properly winterize their vehicles before cold weather storage. Critically, this must be framed as a recommendation, not a requirement. Something like the tenant is encouraged to winterize their vehicle prior to winter storage, not tenant is required to winterize by November 1st. The recommendation language puts tenants on notice and demonstrates that you've done your advisory duty. The requirement language creates an obligation you're unlikely to enforce and a liability you don't need. Clause 6, operator's right to photograph. Your lease should include a provision that gives you the right to photograph the stored vehicle at any time during the storage period for facility management, safety, or documentation purposes. This is distinctly different from moving condition documentation. It covers a situation where you need to document a vehicle that appears to be leaking fluid, maybe, or a vehicle that's been abandoned and you're beginning the lien process, or any other operational situation where photographic documentation is warranted. Without this clause, a tenant could argue that your photographs of their vehicle were taken without their authorization. Clause 7 is indemnification for damage during the tenant access. This is one of the most important clauses in boat and RV lease and one of the most commonly underspecified. Every time a tenant drives their boat, trailer, or motorhome through your facility, there's a possibility of an accident. Could hit another vehicle, damage infrastructure, causing harm to a third party. Your lease should clearly establish that the tenant is responsible for any damage caused during their access to the facility and that the operator is indemnified from liability arising from the tenant's use of the facility. This doesn't eliminate your responsibility to maintain a safe facility. It establishes that the tenant's conduct during access is their responsibility. So work with your attorney on the specific language. Broad indemnification clauses can be unenforceable if they're too sweeping, but a well-drafted clause provides meaningful protection. Clause 8, abandon vehicle process tied to state lien law. This is the one that catches operators most off guard. When a self-storage tenant abandons their unit, the lien process is relatively standardized under the state self-storage lien laws. When a boat and RV tenant abandons a titled vehicle, the process is often different and varies significantly state by state. Some states require you to go through the DMV to obtain a title lien on an abandoned boat or RV. Some require a court process. Almost all require specific notice procedures that differ from self-storage lien notice requirements. Your lease should reference the applicable state law and include the specific procedural steps your state requires. If your lease was drafted without this clause, or if it references self-storage lien law without addressing titled vehicles, you've got a gap worth closing before you need it. 2 practical notes on implementation here. First, get your lease reviewed by an attorney who has experience with boat and RV or marina storage leases. Not a general real estate attorney who will adapt a self-storage template. These specific clauses we covered today require practitioner level knowledge of how they've been tested in disputes and lien proceedings. The cost of a proper lease review is modest compared to the cost of a bad dispute. I highly recommend connecting with an attorney in your state who's handled boat and RV abandonment cases. They'll know exactly what your lease needs. Second, audit your current lease against these 8 clauses. If you're already operating a boat and RV facility, pull out your lease and check it clause by clause against this list. For each gap you find, note it and take it to the attorney for a targeted amendment. You don't have to rewrite the entire lease. You can just add addenda that addresses the missing provisions for new tenants while you update your master template. Here's the frame. Self-storage lease and a boat and RV lease are not the same. Oh, they shouldn't be. The asset has a title, the process has different laws, the disputes have higher stakes, so get the lease right before you need it. All right, next up, day 50, managing seasonal demand, spring move out, summer gap, fall rush. We're going into the cash flow pattern that every boat and RV operator needs to plan around and the strategies that turn seasonality from a problem into an advantage. Please like this video if the 8 clause framework gave you something specific to check on your current lease. Check in, check on. That's exactly the kind of thing that prevents expensive problems in the future. Subscribe so you don't miss day 50. The seasonality episode is one of the most operationally practical in this section because we're going to be talking about cash flow planning, rate strategy, and occupancy management across a full seasonal cycle. And go ahead and share this with a boat and RV operator who's running a facility with an adapted self-storage lease. This episode is the reason to get it reviewed, and share it in general. I've told you a million times why. If you've been following this series, it's better for you than it is for me. Trust me. StorageMoguls.ai has the full lease clause checklist for boat and RV facilities and the attorney referral framework for finding the right legal source in your state. It's free to join. So join Storage Moguls and get the lease right. Another reason you should share, I just thought of, share it with people you want in our community. The community is only going to be as good as the people that participate in it. So if you know some sharp people who are entrepreneurs or want to get out of their day job and are good people, share it with them specifically. Just thought of that one. Protect what you've built before something goes wrong. Join Storage Moguls. See you tomorrow.